Has been issued. Thereafter, what has been done? Third, Miss B. Bhuya, London Senior Counsel, assisted by
Arda.
Miss R. Das, for the petitioner, who has drawn the attention of this court to the order dated 10/3/2025, requiring personal appearance of the sole respondent, para, and fixing today at 10:30 a.m. for the para. Office note dated 13/3/2025. However, is not explicit with regard to the service of, with regard to affecting service of notice upon the respondent. And the only note is that notice was issued by usual process on 13/3/2025. Para. The present being a contempt case wherein the aspect of penalty may also arise, the confirmation of service acquires significant importance. Para, in view of the above, the matter is adjourned to be fixed, adjourned and fixed on
4th of April.
will be too early. We'll have it on 10th of April. 10th of April, before which date the registry will put a fresh note on the aspect of service of such notice. First of the direction for personal appearance as given in the order dated 10/3/2025 is in force, and on the next date, the respondent is required to be personally present at 10:30.
I didn't want.
Yes.
The judgment by the impugned judgment, I have been convicted under section 4 and sentenced to my lord for 10 years. Now the basic, my lord, the ground, my lord, is that the age of the victim has not been proved as mandated by section 94(2). And secondly, though the allegation of penetrative sexual assault, but then medical report does not justify at all. And so far as the eyewitness is concerned, though the victim has stated, but she is not corroborated by the others. The story, as per the PW1, she stated that she went to the residence of PW3 and narrated the story. What had happened incident, and there the PW4 had come, but both these witnesses said that nothing has been stated.
What is the age?
Age according to them 11 years, but we have been arguing that she is more than 18 years. Though she studied in the school certificate has not been produced, only a transfer leave certificate has been produced, and that also not approved as required by the law. First of all, the document itself is not incorporated in section 94(2). It is only a leave certificate and transfer certificate. And
So what was the basis of ascertaining the age? There are 3 modes in 94.
logic. Now,
The birth certificate, the school certificate, and the ossification test. What was done?
Birth certificate, matriculation certificate, then corporation certificate,
Then
then
ossification test.
ossification.
Now what in the, in the,
Based on the document that was submitted, that transfer certificate, based on that.
school certificate was taken into
It
consideration.
is not a school certificate, it's a transfer certificate.
Understood. No. You said that that is not one of the recognized modes under 94.
Lordship, Lord,
During the medical examination of the victim,
Lord.
was the age also determined?
Age has been said in between 14 to 18, 14 to 16,
On the basis of?
on the basis of ossification test.
Then,
But then that is, it is only for the purpose of corroborating the main, substantive evidence which need
no,
to
that
be
is the
linked.
substantive evidence. There are three modes.
Only in case of absence of those documents.
Yes, if you say that the transfer certificate is not a certificate which is recognized under 94, you fall back on the third. If there was no ossification test, no opinion by the doctor,
Right.
and one document was relied upon so far as the age is concerned, at this stage,
Right.
you may still have this point urged at the
Agree,
time of the
agree,
hearing,
agree.
but we are on the prima facie
Right,
view.
it's true. But your lordship will get to see, my lord, is third category of ossification test would come only in absence of those. Now
Yes.
here it is not that, not a case that the documents is absent. It has come on record that she goes to the school,
Yes. Now, if the document is not produced, then what do you do?
my lord,
If the document is not, suppose there is a birth certificate not produced,
not produced.
there is a school certificate not produced, then what do you do? That is why you fall back on the third aspect, ossification test under 94.
My lord, the,
It's a recognized mode.
no, that is only in case of, my lord, in absence.
That is in absence, it is
Lord,
not
but
proved.
then the prosecution, my lord, the investigating officer made no endeavor to collect those documents. It
Not
was very
make,
much
not
available.
make, not make much of a difference in consideration of an eye. I think you press on your, at this point in the main appeal.
Considering
As
the,
the, as the.
LCR, sir, I-
LCR has come, we'll direct paper, preparation of the paper book. Prosecutrix
my lord, the
view,
what I am harping on, my lord, section 94(2), the third category, and only in the absence of.
Yes.
There has to be, my lord, materials to show that these documents are absent. The document is missing or has lost. But here no attempt has been made. But the police has seized the transfer certificate. And
See, once a transfer certificate is there, you are not believing in the transfer certificate. Ossification has been done. Then you say that no, this cannot be a double-edged sword. You have to be consistent on one view. Either you go by the transfer certificate. If had it been a case, the transfer certificate shows an age which is more than the age prescribed, whereas the ossification shows the transfer certificate is maybe it's not a mode recognized under 94, but it is corroborating ossification.
but there, my lord, the medical evidence would be, my lord, for the purpose of corroboration to the, my lord, substantive evidence. What is the
No,
certificate?
it's not a corroboration. It's a recognized mode, 94. It's not
94.
corroboration.
Lordship, my lord.
It's
Therefore,
a
my lord,
mode. How do you
Yes,
determine,
ma'am.
how do you
so
get,
that will be
how
only.
do you establish the foundational facts in a POXO case?
Lordship.
There is 29, 30 is there, presumption.
Right.
But first, you have to make out, you have to have the foundational facts proved.
Right.
Presumption
yes, sir.
automatically is
Yes,
not
my
there.
lord.
The presumption of innocence is
Yes.
always there,
Lordship.
in spite of the 29, 30. That is the law. Foundational facts proved, then the burden will come to you. And how do you have the foundational facts regarding the age of the victim? You fall back on 94.
My lord,
I think
am
we'll
only on
consider,
the
we'll
base-
consider the appeal, Mr. Saikya. Records have come.
Yes, ma'am.
Heard three, P.J. Saikya, Leonard Senior Counsel, assisted by Baudelaire, J. Baudelaire, P. Baudelaire, for the P. Baudelaire, Leonard Counsel for the applicant. Full stop. The senior counsel has submitted that the age of the victim has not been properly proved, and therefore the application of POXO itself would not be proper POXO Act. Full stop. He has also drawn the attention of this court to section 94 of the
Justice Care and Protection
Juvenile Justice Care and Protection
of Children Act 2015.
yeah, 2015, and has contended that without there being any endeavors to have the documentary evidence so far as the age of the victim is concerned, comma, the ossification test has been relied upon to determine the age. Full stop. Para. On the other hand, Ms. B. Bhuyadharan, APP, has submitted that ossification test is one of the prescribed modes under section 94 of the said act, and therefore there is no error in the application of the POXO Act. She has also submitted that it is not the case of the defense. No, she has also submitted that the age of the victim is 11 and is not on the verge of attaining majority. And therefore, there is no controversy at all regarding the age of the victim who is a minor. Sarah? Sri U. Chaudhary, learned amicus, legal aid counsel, appearing for the respondent number 2, has endorsed and supported the views forwarded by the learned APP. Full stop. Para. After consideration of the rival submissions, we are of the view that instead of expressing any merits, any opinion on the aforesaid issue raised at the stage of consideration of the IA, comma, the said point would be answered if raised at the time of hearing of the appeal. Full stop. The said observation is made so as to avoid causing of any prejudice to either of the parties in the adjudication of the main appeal. Para. Since accordingly, the I stands rejected. Full stop. Since the paper book, since the records have been received, we direct the registry to expeditiously prepare the paper book and list the appeal for orders so as to fix a date of hearing.
Some time period for
Expeditiously, I have said. They'll do it. Nowadays, it's early. Yeah.
public.
See, Mr. Saikya, we perhaps have rejected your, but let it be, you can raise this point in the appeal. We'll consider it. Yeah. No, that point we have not rejected. Point is still open. We have said that we are not considering this point at this stage. Otherwise, prima facie view is not with you, so far as this point is concerned.
Quoted by some of the judgment.
No, that is why you also have more time to elaborate your arguments and to convince us. If you make out a point, we'll definitely consider.
No, this matter relates to the Rohingya refugee who has been detained in the detention center. They have come up with with the same plea that India is not a signatory to the UN convention, so they cannot hand over to UNHCR. Now, what do? You keep him as a guest in the detention center. Send him back to Myanmar. Something has to be done.
What is your prayer here?
My prayer is to deport him.
How many of you are there?
One. Or hand him over to the UNHCR.
He is in custody under what authority?
No, he has finished his sentence.
He's been acquitted.
He has been.
I mean,
now.
not acquitted, his sentence is complete.
Yes.
What was the sentence? He was implicated in a criminal case.
No, entering India without
Entering
permit.
India.
And that is an offense.
That is
So,
so after that, there are certain restrictions. He cannot be allowed to just move free.
correct.
Therefore, he has to be kept in the detention as per the government.
What was the period of his detention initially?
1 year.
1 year is over.
Yes.
Long ago.
Now, what do you propose to do?
Now, Lordship, we have taken it up with the concerned country to the street. Now, until and unless there is a acceptance from the other country regarding his domicile, we cannot simply push him into that country.
Will he be able, can he be allowed to move around freely in this country?
No, there is a
Yeah.
restriction.
So what do you do then?
Normally, no,
What steps have you taken to report him?
that has been taken up to the Ministry of Myanmar. But the
Where are your governments? Where are the documents?
Document 90 April. Oh, okay.
Have you filed an affidavit here?
not yet, Lordship, I have to space the instructions.
You filed the affidavit this
That-
point,
Affidavit I can-
but this is pending since when? 23, we have not filed a affidavit.
Yes, Lordship.
Where in
State was
25?
State was seven.
Somebody has filed an affidavit.
State
was,
government has filed it.
Okay, what is the state's
No, they have to
stand?
take it- They have to take it up with the Ministry of Home Affairs and the
State
Ministry of External Affairs and the Ministry.
You're representing the Ministry of External
Yes,
Affairs.
sure.
You put your stand on affidavit. This has to be decided.
Yes, okay.
Okay, but do it soon. It's a 23 matter.
Yes,
Heard Ms. M. Hazare, learned senior counsel for the petitioner assisted by Sri D. Khan. First of, also heard Sri R.K.D. Chaudhary, learned deputy at GI. Para. In the affidavit in opposition filed on behalf of the state, it has been contended that the matter has been taken up with the Ministry of External Affairs. Full stop. Sri Chaudhary, the learned deputy AGI, has submitted that steps are being taken with the concerned country, namely Myanmar,
Myanmar,
for
its embassy.
the deportation of the petitioner, which is one of the relief prayed for in this petition. Full stop. He, however, submits that the aspect is still being examined by the concerned ministries. Para. That the central government file an affidavit in this regard, putting thereon the up-to-date status of the process which has been initiated for the deportation of the petitioner. Para. Let such affidavit be filed within a period of 3 weeks.
After that,
After
Within a period of 3 weeks, and the matter be listed on 23rd of April,
yes.
madam, 23rd of.
Happy to law. This is a matrimonial appeal, Lordship. They have filed objection. And
Yeah,
Lordship,
for the respondent.
Yeah.
Yes,
he appeared, Lordship, last week.
okay.
Since 1/6/2022, they are not living together, Lordship. She was driven.
In view of the above, the court is of the opinion that no case for interference is made out and accordingly the petition is dismissed.